I'm Alan Lomax, and I am a citizen of Jackson County and glad to be here with you in Swain this afternoon. I'm a person, and all of you are persons out there. This is the Articles of Organization for my corporation. This is not a person. But the Supreme Court, in their activist judgments over the last 150 years, have decided that this piece of paper is a person. And not only is this a person, this person has more rights than I as a person have, or as you as a person have, or as we as persons together have. That's a problem for our democratic republic. And it cannot continue to stand as long as this has more rights than you and I have. So this afternoon we're going to look at a timeline and see how it came about that this piece of paper has more rights than anyone else in this room. So Rick, I'm going to turn it over to you, and Rick is going to be our narrator this afternoon. After Rick is finished with his narrative, then group number one, which will be the cards 1 through 12, you will come up here and just stand in a semicircle around the table here, and Marcia has given the preliminary instructions, and so we're going to begin with that.
We're gathered here together this afternoon to celebrate Martin Luther King and the humanitarian work he did. The spirit in which he worked has greatly improved the lives of all people in this country. However, his work is not done, and because of this, his spirit lives on. There's a movement in this country to diminish the power of your vote. When the U.S. Supreme Court declared that corporations are legal people too, and that they had the right to speak through their great wealth, they opened the floodgates of money to control the future elections. Remember, the sole responsibility of any corporation is profit. Nowhere is there a corporation charter that describes them as persons. Fortunately, there is a counter movement that disagrees with this concept. It is known as Move to Amend, and its purpose is to pass a constitutional amendment to negate the Supreme Court ruling, the only way that the ruling can be changed. To everybody in this room, I extend this message. Whatever issue is your particular civic passion, Move to Amend wants to collaborate with you to create a democracy in our country that is truly legal for all of the we people. The scope of Move to Amend encompasses all issues for which corporate control is a threat. We hope you will broach this topic in the open discussion afterward. Move to Amend has concluded that its fight for the 28th Amendment to legalize democracy must include a commitment to dismantle racism and other systemic oppression. There's a good chance that the process itself of your participating in this makes this timeline will clarify for you how important this inclusion is. First off, a few points about the issues of rights and personhood. Rights are granted to legal persons only by law. When the Bill of Rights was added to the Constitution, only 5 to 8% of we the people were legal. In 1791, an overwhelming majority, women, poor folks, First Americans, African Americans, and indentured servants were not legal persons. You had to be white, male, and a property owner to be a legal person. If you lacked that, just one of the criteria, you were not legal. As for the topic of personhood, Move to Amend's 28th Amendment includes 2 bites, so to speak, of the corporate problem because it insists on clarifying both that corporations are not people and that money is not speech. Other movements have taken off after the Citizens United decision in 2010, but those groups have decided to attempt less. They usually opt only for the money is not free speech part. And when and if they include abolishing corporate personhood, they fail to insist on a constitutional amendment.
Santa Clara County versus Southern Pacific Railroad, 1886. Without any formal argument, the court declares a corporation a person with the same rights as human beings. They grant them the 14th Amendment right to equal protection that was supposed to protect recently emancipated black folks. Justices have since struck down hundreds of local, state, and federal laws enacted to protect people from the corporate harm caused by these discriminations against corporations, because these discriminate against corporations.
Hale versus Hinkle, 1906. Corporations get Fourth Amendment search and seizure protections. Corporations use this right to demand that regulators get warrants before they can inspect businesses for violations of labor and environmental laws.
Dodge versus Ford Motor Company, 1919. The Michigan Supreme Court rules that a corporation exists to maximize profits for its shareholders, regardless of the impacts on the planet, economy, or health and safety. This ruling mandates perpetual growth and practically guarantees human and environmental abuses.
Pennsylvania Coal Company versus Mahon, 1922. Corporations get Fifth Amendment protections against the government taking their property without compensation. They use this right to argue that any law that infringes on their profit is a takings, and they can sue to recoup all the profits that they were making and would have made if the law hadn't passed.
Lewis K. Liggett Company versus Lee, 1933. The people of Florida passed a law that levied higher taxes on chain stores than local businesses. The Supreme Court overturned because it discriminated against chain stores and therefore violated corporate 14th Amendment rights to equal protections.
Buckley versus Vallejo, 1976. The Supreme Court rules that corporations have First Amendment rights to freedom of speech. Since corporations do not have mouths to speak with, the court rules that they may speak by spending money in elections. This opened the door to a glut of corporate spending in the political process.
First National Bank of Boston versus Bellotti. Corporations use their First Amendment rights to overturn the state restrictions on corporate spending on political referenda. This precedent is used with Buckley versus Vallejo to thwart attempts to remove corporate money from politics.
Pacific Gas and Electric versus Public Utilities Commission in 1986. Although PG&E has a monopoly on utilities in California, they refused to allow an advocacy group to use extra space on their billing envelope to encourage energy conservation. The court sided with PG&E, upholding the corporation's right not to speak and protecting what they call the corporation's freedom of mind.
Supreme Court International Dairy Foods Association versus Amistoy in 1996. Supreme Court overturns a Vermont law requiring the labeling of all products containing bovine growth hormone, citing the corporation's right not to speak and extending it to statements of fact as well as statements of opinion.
Citizens United versus Federal Election Commission, 2010. Supreme Court reaffirms that a corporation is a person and states that any restrictions on corporate money in elections violates the corporation's First Amendment right to free speech. This ruling overturned most provisions of McCain-Feingold legislation that restricted corporation money in federal elections and reversed a 100-year precedent of congressional authority to regulate federal elections. It opens the floodgates to unlimited corporate spending in elections. $6 billion is spent in the 2012 election cycle.
What about the 95% of people who originally did not count as legal persons? As humorist and social commentator Molly Ivins famously said, the whole history of the United States can be seen as groups of people forming social movements to drive themselves into the phrase, "we the people." Ms. Ivins was pointing out that those movements were pushing for the rights of legal persons so that they could protect their land, their labor, and their dignity. So how did that happen?
Bill of Rights. Outraged revolutionaries reject the Constitution as an elite property document and refuse to ratify it unless it contains basic political protections against the tyranny of the state. Their struggle is successful, and they drive through 10 amendments to the Constitution that protect people's rights to freedom of speech, assembly, religion, and the press, as well as others.
The 13th Amendment, 1865. Slavery is abolished in the U.S. and any place subject to its jurisdiction.
The Civil Rights Act of 1866 extended the rights of emancipated African Americans by stating that any person born in the United States, regardless of race, is a U.S. citizen.
Fourteenth Amendment, 1868, black males are now citizens. The law cannot discriminate against them in any way.
Fifteenth Amendment, 1870. Black males get the right to vote.
Social change in 1886. The year that the Supreme Court first gave corporations human rights, this is what the rest of the country was up to. Campaign for the 8-hour workday. Knights of Labor membership 1 million with 60,000 black and even more women members. Farmer Alliance reaches 100,000 members. Populists draw up founding documents to demand debtors' right and fight the railroad lobby. Eugene Debs builds the Brotherhood of Locomotive Firemen. Das Kapital by Karl Marx, published in English. Police brutalize labor activists in the Haymarket Massacre.
th Amendment, 1913. The U.S. Senate is now elected by the people instead of appointed by state governments.
th Amendment, 1920. Women finally get the vote after 75 years of struggle.
Brown versus the Board of Education of Topeka, 1954. The Supreme Court recognized that separate was not equal and ruled that public schools cannot be racially segregated.
Civil Rights Acts, 1960, my birth year, established federal inspection of local voter registration polls. Go figure. I'm going to insert 1964 prohibits discrimination based on race, color, religion, sex, and national origin by federal and state governments. Some of you know me here, Mr. JQ. anybody interested in me having to use the 1964 Anti-Discrimination Act on the dinner train with the Great Smoky Mountain Railroad in 2006. 1968 prohibits discrimination in sale, rental, and financing of housing based on race, creed, and national origin.
The 24th Amendment, 1964, abolished poll taxes, which were used to keep blacks and others from voting in some states.
Twenty-Sixth Amendment, 1971. Voting age changed from 21 to 18 years of age. Passed to recognize that if 18-year-olds could be drafted into military service, they should be allowed to vote.
Roe versus Wade, 1973. The Supreme Court rules that state statutes against abortion are vague and infringe on a woman's 9th and 14th Amendment right to privacy. Abortion is legalized in the first trimester of pregnancy.
Most members of Move to Amend, as well as many here today, already know much of the basic story of the first two timelines. But there's one more timeline that we have to address if we want to understand how power and law have worked in this country. Most movements that achieved the people's rights, which you just enacted, were pushing for something broader than the specific legal goal. For instance, the women's right to vote was symbolic of women's rights to full equality. The voter rights, symbolic of full citizenship. After each victory, however, some kept their eyes on the full prize, but other movements got distracted and lost sight of the transformative goals. Their legal victories and demands became acceptable in place of their fight for emancipation as fully human citizens. Was it the case of while we slept?
This is Act 10, 1639. This Virginia colony statute grants the privilege of armament to all white men, including indentured servants, but excludes black men.
Negro women not exempted from tax. Act 7, 1668. Virginia colony law declares free English and free Negro women will be equally taxed, but Negro women will still be without rights.
An amendment to Act 10, done in 1680, called an Act for Preventing Negro Insurrection. Blacks are banned from carrying weapons of any kind, and if they presume to physically resist any Christian, in quotes, they are punished with 30 lashes on his bare back, well laid on. Blacks could also be legally murdered if they are found lurking in obscure places, avoiding labor.
Slave and Servant Codes, 1680 to 1705, established the term slave as equivalent to Negro, while servant now refers only to non-blacks or white persons. Slaves can be accidentally killed by their masters without penalty and are slaves for life along with their children. In contrast, servants are granted new protections and privileges, including the right to take their master to court, the right to marry another European immigrant, and the guarantee of a severance pay and a plot of land when freed from service. Black-white marriage is banned, and interracial sex is fined.
U.S. Constitution, 1789. The writers of the Constitution were very interested in protecting their property and increasing their wealth. They wrote a founding document that protected property over people and removed the government from the will of the mob. Without using the word slave or slavery, they made slavery legal and institutionalized it.
The Naturalization Act, 1790. Immigrants are allowed to become citizens, but only if white. Without citizenship, non-whites cannot vote, own property, file lawsuits, or testify in court.
Bill of Rights, 1791. The first 10 amendments to the U.S. Constitution were adopted to protect we the people from excesses of government. At this time, we the people meant only white males who owned property and were over 21 years old. Only 5 to 8% of the people in the United States counted as people and got the protections of the Constitution.
The Indian Removal Act of 1830. Indigenous peoples are forced from their homelands east of the Mississippi River. Over 10 years, approximately 100,000 native children and adults marched thousands of miles west into unknown desert territory. 15,000 people died along the way.
Cherokee Nation versus State of Georgia, 1831. A Cherokee delegation sues the state of Georgia for stripping their people of land and rights, but the court rules they are a domestic dependent nation unable to claim status in court, validating Cherokee removal and state seizure of their land.
The People versus Hall, 1854. Non-whites are barred from testifying in court. California Supreme Court reverses murder conviction of a white man, dismissing the testimony of a key Chinese witness, stating that, quote, no black or mulatto person or Indian shall be allowed to give evidence in favor of or against a white man, quote, unquote.
I'm the beneficiary of the Naturalization Act. Dred Scott versus Sanford, 1857. A slave sues his owner for freedom in a state where slavery is banned. The U.S. Supreme Court rules that Negroes are not U.S. citizens under any circumstances and have no rights which any white man is bound to respect. Free blacks are taxed like whites, but receive none of the rights and protections of citizenship.
The Homestead Act, 1862. 50 million acres of formerly indigenous land in the West, seized by U.S. invasion in violation of treaties, is distributed by the government at low cost to white settlers only. An additional 100 million acres of land are given for free to railroad developers.
Minor versus Happersett, 1874. Women argued that the 14th Amendment Equal Protection Clause ensured their right to vote. The Supreme Court rejected their claim, stating that the 14th Amendment was only applied to black males.
Chinese Exclusion Act, 1882. Bans immigration of both skilled and unskilled Chinese laborers. This act is expanded in 1924 to restrict other Asian immigrants and ban Chinese white marriages in California.
The Dawes Land Allotment Act, 1887, forbids communal land ownership by indigenous people and encourages native people to sell their land to whites, breaks up collectively owned native land and redistributes millions of acres as property to white squatters.
Plessy versus Ferguson, 1896. The Supreme Court ruled that the state laws enforcing segregation by race are constitutional if separate accommodations are equal. Black males effectively lost equal protection rights and access to privileges of the white world.
Johnson-Reed Act, 1924, creates immigration quota system based on national origin favoring Nordics from Northern and Western Europe over the, quote, inferior races, unquote, of Asia and Southern and Eastern Europe.
The National Housing Act, 1934. Following the Great Depression, a federal housing authority is created to provide loans for home ownership. But the FHA standards discriminate against non-whites and deter investment in non-white communities. Known as redlining, this practice boosts the economic value of white neighborhoods relative to non-white neighborhoods.
Labor Relations Act, 1935. Militant workers win the right to unionize, but white labor leaders compromise with Congress to exclude domestic and agricultural workers, who are mostly black, Chicano, and Chinese. Because most labor unions also excluded non-whites from membership, this effectively amounts to labor rights for white men only.
Social Security Act, 1935. This act provides old age insurance for the mostly white workforce of certain industries, excluding domestic and agricultural workers who are mostly non-white.
Japanese American internment in 1942 forces all Japanese American and Japanese residents living on the west coast of the U.S. into unsanitary, fenced concentration camps called war relocation camps. Over 111,000 people are interned, 62% of them American citizens.
This was a GI Bill passed in 1944. The Servicemen's Readjustment Act offers education and housing subsidies to returning war veterans, but severe social discrimination, poverty, and lack of education prevents black veterans from receiving these benefits, while white veterans benefit disproportionately.
The War on Drugs, 1971. President Richard Nixon declares a war on drugs which disproportionately and violently targets economically impoverished communities of color for the next 40 years, leading to mass incarceration for drug-related offenses. White populations are relatively unaffected.
The Three-Strike Law, 1994. 26 states pass mandatory minimum sentencing, laws that require jail time for first and second offense, and life in prison for crimes as petty as stealing a pair of gym socks, shoplifting, a pair of baby shoes, and stealing a slice of pizza. In California, blacks make up only 7% of the population, but 45% of those convicted of a third strike.
Post 9/11 disappearances. Immediately following the attacks on New York City, thousands of Arab, Muslim, and South Asian men living in U.S. cities are snatched from their homes, places of work, and off sidewalks by federal agents without warrants or charges. Shackled hand and foot, detained, and prevented by Federal Bureau of Prisons from contacting family, press, or attorneys. Many were held for months in abusive conditions. Not one of these thousands has ever been publicly charged with terrorism.
National Security Entry-Exit Registration System of 2002. Known as NSEERS, this mandates that all nationals over the age of 15 from 25 specific countries, all of them Arab or Muslim apart from North Korea, report to the government to be fingerprinted, photographed, and questioned as part of a special registration program. People were given no individual notice of these requirements, but if they failed to register, they could be deported or charged with criminal offenses.
Arizona Senate Bill 1070, 2010, the year. Police are required to ask individuals to present their citizenship or immigration documents if they have undefined, reasonable suspicion that the person stopped may be in Arizona illegally, justifying racial profiling and harassment.
Alabama House Bill 56, 2011. In addition to police, school administrators at the high school, middle school, and elementary levels are required to demand citizenship or immigration documents for any child whom they reasonably suspect is living in Alabama illegally. Children are racially singled out in classrooms in front of their peers and handed papers from their teachers demanding to see immigration or citizenship documents.
NYPD Stop and Frisk, 2011. In 2011, New York City's discriminatory stop and frisk program continues to escalate, with over 680,000 public police stops made on the street, and 84% of those stops being of blacks or Latinos. Justified as a gun control measure, less than 0.2% of stops turn up guns, while 88% of stops result in no charges at all.
What I've been hearing this afternoon makes a big impression on me, and I expect on the rest of you too, particularly this last section. It seems obvious to me that we've got a long way to go. We're not done yet. Democracy has not been legalized. And here's the 28th Amendment that is being proposed by move to amend that we are here to talk about today. Artificial entities do not have constitutional rights, and money is not free speech. Campaign spending can be regulated, The national grassroots move to amend that is growing exponentially right now has put forth the motion for this 28th Amendment to the Constitution. It insists that rights be returned to human beings.
Being a legal person in the United States bestows not just the backing of the state, but more subtle is the intrinsic worth of cultural legitimacy. There's a two-way relationship that occurs between law and culture, which can dramatically affect someone's perceived value, that is, their decision-making power, their safety, their livelihood, their opportunities. As corporations have been accorded personhood or become so-called legal people, they not only have gained the power to decide on our democracy as in elections, they have also begun to receive the added benefits of cultural legitimacy, the idea that they deserve to participate and decide. Certainly not all corporations are corrupt, but Move to Amend is seeking to change, to differentiate, and the negative climate of corporate culture. Our commitment to legalize the rights of all systemically disadvantaged human persons will also curb perceived cultural value of the dishonest corporations. Failure to include the legal rights of disadvantaged citizens will render the Move to Amend goal of achieving the 28th Constitutional Amendment half-empty. To work for a half measure would be merely legalistic and lack moral weight. Democracy cannot parade under the charade of equality, not when only 1% holds most of the country's wealth. We can no longer seek to rectify only the corporate problem, not without shining a light on those disadvantaged citizens over whom unjust corporate advantage has been gained. Move to Amend's movement is putting the public on notice that they intend not to be just inclusive, but proactive. Our grassroots movement has set out to be prepared for future problems, to remember what happened when we lost sight of the bigger picture, and to hold fast to the advances gained thus far. This time, we won't be caught unaware.
Every time we go through this timeline, it touches me really, really deeply. It is every single amendment to the Constitution have been fought for and hard won. And it's a continuing and an ongoing process. And our country, we often think of America as the shining light in the whole entire universe, and we have heard time and time again that we live in the greatest country in the world, and I'm sure no one in here has ever forgotten that. But there, as we go through this timeline, it is certainly a reminder that democracy has never really been won for we the people, that we have been a nation based upon preeminence of property over people. And as slavery is the process of making people into property, corporate personhood is the process of making property into people. Both stem from the same thing, and as you saw in the timelines here, they are totally and completely intertwined. And they stem from a process of oppression of the many for the benefit of a very, very few. And it is time to make a change, and it is time to bring democracy home to the greatest country in the world.